All right, we can go on the record. Good morning, everyone. My name is Jennifer Grace. I'm the Public Utility Law Judge assigned to handle this case, which is PSC case number 9733, Chaberton Solar Ramiere CPCN. It's a 3.0 megawatt solar photovoltaic generating facility proposed in Montgomery County, Maryland. We can start with the service list, the appearances from the parties. Chaberton.
Good morning, Your Honor. My name is Andy Flavin with the law firm Troutman Pepper Locke, LLP, on behalf of the applicant, Chaberton Solar Ramiere, LLC.
Good morning.
Good morning, Your Honor. Assistant Attorney General Steve Tolson on behalf of the Power Plant Research Program.
Good morning.
Good morning, Your Honor. Diane Kilcoyne. I'm Assistant County Attorney from Montgomery County, Maryland.
Good morning. Sorry.
I'll try it again. Good morning, Your Honor. Diane Kilcoyne, Assistant County Attorney from Montgomery County, Maryland.
Good morning.
Good morning, Your Honor. Harrison Scher on behalf of the Commission's technical staff.
Good morning.
Good morning, Your Honor. Matthew Mills on behalf of the Maryland National Capital Park and Planning Commission, which I'll just call Park and Planning moving forward. Thank you.
Good morning.
Good morning, Your Honor. I'm William Sheehan for the interveners, Montgomery Countryside Alliance, Sugarloaf Citizens Association, Montgomery County Farm Bureau, and the Montgomery Agricultural Producers.
Good morning. All right, do we have any preliminary motions or other items to take up? Okay, Chaberton, it's your case.
Thank you, Your Honor. Would Your Honor like to start with identifying exhibits on the proposed exhibit list?
Sure.
Thank you. Your Honor, I believe the certificates of publication for the pre-hearing conference was previously identified as applicant exhibit number 1. That was filed on June 24th, 2024 under mail log number 310408.
Yes, and that has been admitted.
Thank you, Your Honor. Your Honor, may we please have marked as applicant exhibit 2, cover letter and certificate of service for the application filed on April 18th, 2024 under mail log number 309043.
Applicant exhibit 2 is marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 3, the petition, also filed April 18th, 2024 under mail log number 309043.
Applicant exhibit 3 is marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 4, the verification accompanying the application, also filed April 18th, 2024 under mail log number 309043.
It will be so marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 5, the application appendix, also filed April 18th, 2024 under mail log number 309043.
Applicant exhibit 5 is marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 6, the ERD narrative, filed April 18th, 2024 under mail log number 309043.
Applicant's ERD narrative will be applicant exhibit 6.
Thank you, Your Honor. May we please have marked as applicant exhibit 7, the ERD appendix A, which was the initial conceptual site plan filed with the application on April 18th, 2024 under mail log number 309043.
It'll be so marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 8, ERD appendix B, which is the USDA NRCS soil report, filed April 18th, 2024 under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 9, ERD appendix C, which is the geotechnical assessment report, filed April 18th, 2024 under mail log number 309043.
Yes, sir, so marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 10, ERD appendix D, which is the United States Fish and Wildlife Service correspondence, filed April 18th, 2024 under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 11, ERD appendix E, which is correspondence with the Maryland Department of Natural Resources, filed April 18th, 2024 under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 12, ERD appendix F, which is correspondence from the Maryland Historic Trust, filed April 18th, 2024 under mail log number 309043.
Applicant exhibit 12 is marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 13, ERD appendix G, which was the aquatic resource investigation, filed April 18th, 2024 under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 14, ERD Appendix H, which were interconnection study documents filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 15, ERD Appendix I, which was the glare analysis filed with the application on April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 16, ERD Appendix J, which is the FEMA firm map filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 17, the ERD Appendix K, which is the Forest Conservation Plan and Forest Stand Delineation, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 18, ERD Appendix L, Phase 1 Environmental Site Assessment, and this is Part 1 of 2 of that document, filed April 18th, 2024, under mail log number 309043.
18 is marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 19, ERD Appendix L, which is the Phase 1 Environmental Assessment, Part 2 of 2, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 20, ERD Appendix M, which is correspondence with Montgomery County, filed April 18th, 2024, under mail log number 309043.
ERD Exhibit M, Montgomery County Correspondence, is marked as applicant Exhibit 20.
Thank you, Your Honor. May we please have marked as applicant Exhibit 21, ERD Appendix N, the Vegetation Management Plan, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 22, ERD Appendix O, which is the Subscriber Organization Approval, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 23, ERD Appendix P, which is the Water Use Exemption Application, filed April 18th, 2024, under mail log number 309043.
23 is marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 24, ERD Appendix Q, which was the Environmental Justice Screen Report, or EJ Screen Report, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 25, ERD Appendix R, which is the Construction Access Diagram, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 26, ERD Appendix T, which was the AVERT results, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 27, ERD Appendix U, which is the PV cyst analysis, filed April 18th, 2024, under mail log number 309043.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 28, the public version of ERD Appendix S, which are the JEDI results, filed May 16th, 2024, under mail log number 309703.
28 and 28C will be the public and confidential Appendix S JEDI results. So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 29, the responses to the PPRP Data Request 1, filed on May 22nd, 2024, under mail log number 309043.
Applicant Exhibit 29 will be the responses to PPRP Data Request 1. Hang on just a second. Mr. Court Reporter, are you still getting good sound despite the, I guess, the air conditioning noise in the back?
Yes, Your Honor.
Okay, thank you. Go ahead.
Thank you, Your Honor. In Your Honor, may we please have marked as applicant Exhibit 31, or excuse me, applicant Exhibit 30,
Yeah.
I apologize. The Certificate of Compliance filed May 29th, 2024, under mail log number 309925.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 31, the Certificate of Publication for the first public comment hearing, filed August 21st, 2024, under mail log number 311831.
So marked.
Thank you, Your Honor. May we please have marked as applicant Exhibit 32, the updated conceptual site plan, filed March 21st, 2025, under mail log number 316952.
The March 21st updated conceptual site plan will be applicant exhibit 32.
Thank you, Your Honor. May we please have marked as applicant exhibit 33 the final proposed decommissioning plan, the clean version, filed March 21st, 2025, under mail log number 316952.
The applicant final proposed decommissioning plan filed March 21st is applicant exhibit 33.
Thank you, Your Honor. And we please have the marked as applicant exhibit 34, the red line version of that final proposed decommissioning plan, also filed March 21st, 2025, under mail log number 316952.
Yes, sir, so marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 35, the certificates of publication for the second public comment hearing, filed April 14th, 2025, under mail log number 317986.
So marked.
Thank you, Your Honor. And may we please have marked as applicant exhibit 36, the supplement to the certificates of publication for the second public comment hearing, filed April 14th, 2025, under mail log number 317995.
So marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 37, the sign affidavit, filed April 15th, 2025, under mail log number 318039.
So marked.
Thank you, Your Honor. May we please have marked as applicant exhibit 38, the updated conceptual site plan, filed May 1st, 2025, under mail log number 318495.
The updated conceptual site plan dated May 1st is applicant exhibit 38.
Thank you, Your Honor. May we please have marked as applicant exhibit 39, the certificates of publication for the third public comment hearing, filed May 19th, 2025, under mail log number 318948.
So marked.
Thank you, Your Honor. And may we please have marked as applicant exhibit 40, the settlement status update, filed May 27th, 2025, under mail log number 319143.
So marked.
Thank you, Your Honor. And that concludes the applicant's exhibits that are not testimony at this point. Depending on how Your Honor would like to handle this.
Is there any objection to the admission of applicant exhibits 1 through 40, including the confidential exhibit?
No, Your Honor.
No,
No objection.
No objection.
Applicant exhibits 1 through 40 are admitted.
Thank you, Your Honor. And at this point, Your Honor, would we be okay to call our first witness?
Yes, sir.
Thank you, Your Honor. At this point, the applicant would call Mr. Ryan Boswell to the stand.
While Mr. Boswell's getting situated, I'm going to see if I can get somebody to turn that off so that we can all hear. Be right back. You can stay on the record. Okay, go ahead, Mr. Reporter.
Good morning. Raise your right hand. Do you swear or affirm on the authority of perjury to tell the truth, the whole truth, and nothing but the truth in the testimony that you're about to give?
I do.
And could you please state and spell your first and last name?
My name is Ryan Boswell, RyanBoswell.
Hey, could you please give us your business address?
1700 Rockville Pike, School 305, Rockville, Maryland.
Thank you.
Go ahead.
Thank you. Good morning, Mr. Boswell.
Good morning.
Could you please state your title with Chaberton and your role?
I'm Vice President of Development with the applicant.
Thank you, Mr. Boswell. And did you cause to be filed, in this case, the direct testimony of Ryan Boswell, which included 187 pages, filed on August 16th, 2024, under mail log number 311749?
I did.
And Mr. Boswell, did you also cause to be filed the rebuttal testimony of Ryan Boswell, which was 41 pages, on June 17th, 2025, under mail log number 319675?
I did.
Mr. Boswell, do you have any changes or corrections to your direct or rebuttal testimony?
I do not.
And if I asked you the same questions here today that appear in that that direct testimony and rebuttal testimony, would you provide the same or substantially similar answers?
Yes, I would.
And was that direct testimony and the rebuttal testimony prepared by you or under your supervision?
It was.
Your Honor, I'd like to ask that Mr. Boswell's direct testimony be marked as applicant exhibit 41 and his rebuttal testimony be marked as applicant exhibit 42.
Those are so marked.
Thank you, Your Honor. Mr. Boswell is available for cross-examination.
PPRP,
No cross, Your Honor.
Montgomery County,
No cross, Your Honor.
Commission staff,
No questions, Your Honor.
Park and Planning,
No questions, Your Honor.
interveners. Go ahead. Can you turn the mic to face you?
Oh, sure. Is that better?
Yes.
Good. Morning, Mr. Boswell.
Morning, Mr. Sheehan.
We met in April.
Yes, we did.
What's a reasonable date for the Ramiere project to be in operating if it's approved?
I believe it's reasonable that the project could be operating by the end of 2026.
Mr. Boswell, you testified last April in support of Chaberton's application for approval of its Sugarloaf project. That's correct, am I right?
I did provide that testimony, yes.
Yeah, and you said then that Chaberton had several solar projects in operation and about 130 in the pipeline. Do you recall that?
That sounds accurate.
And Chaberton's website now says the number is up to 140. Is that correct?
That sounds reasonable.
And I asked you then how many of Chaberton's project then had violated local zoning laws, and you said none, correct?
That's correct.
Okay. And you said Chaberton has been able to be successful without violating local zoning laws, true?
That is correct, yes.
Is that still true? You don't need to violate zoning laws to be successful?
We have been successful without violating zoning laws, yes.
How many milliwatts in total do those 140 projects represent?
I don't have that number off the top of my head.
Oh, how about an average?
I would estimate somewhere between 50 and 60 megawatts AC.
60 and 50?
Between 50 and 60 megawatts AC.
That's total?
Across, about a dozen projects that are operating. Those that are in the pipeline, I would barely hazard a guess.
Okay. How many of them are as little as 3 megawatts, would you guess?
Probably the vast majority of those are 2 megawatts or less.
Mr. Boswell, the Planning Board and PPRP have both suggested that approval of your application should be conditioned on your implementation of an agrivoltaics plan. Am I right?
That is correct.
And I take it that Chaberton has strongly committed to an agrivoltaics plan.
We are committed to it, yes.
Okay. So would you say that an effective agrivoltaics program is essential to approval of the plan?
We do think that it is consistent with the spirit of the agricultural reserve that we implement agrivoltaics, yes.
Okay. So do you agree that an effective agrivoltaics plan is essential to operation of the project?
I'm not sure that it's essential to the operation of the project. The project would operate just fine in absence of agrivoltaics, but we do think that it's a necessary complement to the project.
Okay. Suppose you're unable to implement an agrivoltaics plan while you're operating the project or coexistent with operation of the project. What will happen then?
I would assume that any such lapse in agrivoltaics would be temporary until we found another vendor. I can't conceive of a reason why there would be no agrivoltaics.
Suppose you got no vendor at all.
In that case, we still have the opportunity to plant pollinator habitat. An apiary complementing a pollinator habitat would constitute some form of agrivoltaics.
Are you aware that the Maryland Beekeepers Association has actually conferred with Chaberton and rejected that proposal?
I don't recall that specifically, but they don't represent every beekeeper in the state.
Okay, But you don't deny that the Beekeeper Association has told Chaberton that that's not an appropriate use?
I do recall that some beekeepers in Montgomery County did not express an interest in participating in that project.
All right. Okay. So suppose you have no interest from beekeepers and you have no interest from sheep raisers, and you can't implement an agrivoltaics plan. Is the project going to operate nonetheless?
I think that we would continue to pursue the project, yes. So you have already drafted a request for proposals, an RFP, am I right? Yes, we have.
Have you read it yourself personally?
Yes, it's been some time, but I have read it.
It's quite lengthy, isn't it?
It is.
Would you agree with me that it's also fairly onerous for the sheep owner?
I can't really speculate on whether it's onerous or not. I don't have any experience raising sheep.
Okay. Do you know that it requires the sheep owner to take out an insurance policy and list Chaberton as a covered insured?
That sounds consistent with our requirements.
Okay. What was the what is the acreage of the Sugarloaf project?
It's approximately 11 acres.
And what's the acreage of the Ramiere project?
Oh, I'm sorry, I mixed those up. I thought you were asking a Ramiere.
Yeah.
The Sugarloaf project is approximately 18 acres, and Ramiere is 11 acres.
Okay. And you've got a consultant called Oakavate, is that true?
That is correct.
And they've suggested that for Sugarloaf, the owner of the sheep might make $7,500 a year.
I'd have to review their report, but sounds reasonable.
Okay. Is that $7,500 gross or profit?
I don't know, sir.
Okay. Do you agree that the number would, given that Sugarloaf is 18 acres and Ramiere is 11 acres, that the figures would be lower for Ramiere?
Yeah, presumably. I don't think it was ever the intent that Ramiere on its own would provide a complete living for a farmer.
Okay.
Just as any other farmer wouldn't make a living on 11 acres.
Right. Okay. And this is going to be the proposal would be for the sheep to be on this 11-acre plot on a rotational basis, right? They're 24/7. They come in and out. Is that correct?
Yeah. What Oakavate proposed was a rotational system.
Right. Right. So the proposed responder to your RFP not only has to insure Chaberton, it's got only 11 acres. It can't really make a living on 11 acres, and it's got to rotate the sheep in and out. Mr. Boswell, I suggest to you that you will get absolutely no responses to that RFP, and you can't turn it into an aviary if the beekeepers don't want it. So your
Your Honor, apologize here. I'm going to object to that. That's not a question at all from Mr. Boswell. That's a statement of what Mr. Sheehan thinks may happen
sure.
in response to the
That's a fair objection, Mr. Flavin. I'll rephrase. Mr. Boswell, given the unlikelihood that you're going to get any response to your RFP, is it your testimony that you will proceed without an agrivoltaics program?
I disagree with the characterization that it's unlikely that we'll get a response. We've had several conversations with vendors who are specialized in this area and who are interested in providing their services.
Tell us more about those vendors, please. Who are they?
I don't have names in front of me. Gray's Landscaping is one that is common. They're providers of agrivoltaic services primarily in Virginia at this time, but they're interested in expanding their operations into Maryland.
And are they sheep raisers?
They do raise sheep. They raise some other table crops, among other things. I'm not deeply familiar with their business.
And at what stage are your discussions with them? Have they seen the RFP?
They have taken a look at the RFP. We've had discussions over a number of years, but until we have a project to implement agrivoltaics, we've only advanced that conversation so far.
But you have several projects that you say have already implemented agrivoltaics, true?
We have some projects that we have developed where the long-term owner-operator has deployed sheep for grazing. That is correct, yeah.
How many of those projects have you had?
I'm aware of at least 3 projects where sheep are used for vegetation maintenance.
And how big are those projects?
They vary in size from, let's say, 10 acres to 25 acres.
And you say that the sheep are used for vegetation maintenance, so there's not a sheep farmer actually raising those sheep for market?
I don't know the details of what the owner of those sheep does with the sheep when they're not grazing those sites, but presumably they find some market there. If nothing else, then the fee they're paid for vegetation maintenance.
I see. Chaberton pays the farmer to bring sheep on to eat the vegetation. Is that right?
To be clear, Chaberton doesn't operate the projects it develops, but the long-term owner-operator, in my understanding, does pay for that vegetation maintenance.
Okay. So, Mr. Boswell, let's talk about ownership. You've testified that Chaberton does site selection, project design, and pre-construction. If your application is granted, what does pre-construction mean? Will Chaberton actually build the project, install the panels?
No, we support the long-term owner-operator in mobilizing for construction, but we do not participate in the construction process.
Okay. So when you say the long-term owner-operator, you're going to sell the Ramiere project to a long-term owner-operator?
That is our typical business model, yes.
Okay. Do you have a prospective purchaser for Ramiere already?
We have advertised this project among many in the marketplace, but we're not under contract with any buyer.
Okay. And how does this typically work? You get the application approved, you advertise, a buyer responds, and then what happens?
Then there's a contract for the sale of the project, along with other obligations in that contract, which obligate Chaberton Energy Holdings to support the buyer and the long-term owner-operator in the construction process and eventual operation of the project, and achieving operation of the project. And
what form does Chaberton's contractual responsibilities take after this contract is signed and the project is sold?
I'm not sure that I understand the question.
What are Chaberton's contractual obligations under the sales contract?
We support the buyer in securing all the permits for the project up to and including the building permit. We help them to find qualified contractors to construct the project, and then generally our obligations end at that point that the project mobilizes construction.
Okay, so so once the construction starts, your role stops.
Generally speaking, yes.
Okay. Does the owner-operator undertake any contractual obligation to undertake an agrivoltaics program?
The owner-operator is subject to all of the same obligations as Chaberton Solar Ramiere. In the transaction process, they buy the project company, which owns all the assets and all the obligations.
Okay. So if your application was granted on the condition that it operated at the same time with an effective agrivoltaics program, the new owner-operator would be obliged to honor that commitment.
That is correct.
Okay. What role does Chaberton play in the decommissioning of these projects at the end of their useful life?
Generally speaking, the owner-operator is responsible for decommissioning, except in the event that their business ceases to function, in which case there's a bond placed with the Public Service Commission to cover the cost of decommissioning.
And who supplies that bond, Chaberton or the owner-operator?
First Chaberton Energy Holdings, and then the owner-operator.
Mr. Bosworth, you testified at page 6 of your testimony, quote, "There is limited ability for Montgomery County cited solar projects to contribute to the state's solar energy requirements," close quote. Do you recall that testimony?
I do.
Mr. Sheehan, are you in his direct or his rebuttal?
And his direct, that was at page 6.
Thank you.
And Mr. Boswell, you testified that the Montgomery County zoning laws, quote, "have shifted disproportionately the responsibility of hosting renewable energy structures to other localities." Do you recall that?
Yes, I do.
Mr. Boswell, have you read the testimony submitted in this proceeding on May 15 by Caroline Taylor on behalf of the interveners?
Yes, I have.
Did you see the memorandum to delegate Lily Key that was an exhibit to her testimony?
I have not reviewed that recently, but I did see it when it was filed.
Okay. Did you see that it said, quote, "There are 445 properties in the agricultural reserve that meet the qualifications to have 15 to 15 acre solar arrays per site"?
I did see that.
And did you see the quotation or the sentence in that memorandum that said that 4,462 acres of agricultural reserve land could host solar under the Montgomery County's local laws?
Yes, I did.
Okay. Do you have any reason to doubt those numbers?
I do doubt those numbers for a number of reasons, but I'm not sure how Ms. Taylor formulated that number. There are a number of factors that contribute to a site's suitability for solar, and in our analysis, the number is in fact much smaller than that with the application of the ZTA.
What are your numbers?
Well, in the report that we filed with or the exhibit we filed supporting my testimony, the industry analyzed the zoning text amendment, infrastructure, suitability of sites, environmental restrictions on various parcels, and determined that approximately two 2-megawatt projects would be viable under the ZTA. That estimate was further confirmed by the ZTA impact report, which shows that 2 projects had been approved and 1 was pending.
You say in all of Montgomery County, only 2-megawatt projects can be approved? Is that
I'm
your
sorry,
testimony?
to clarify, that is in the agricultural reserve.
Right. So in the 93,000 acres of the agricultural reserve, you say that only 2-megawatt projects can be built?
Only 2 projects which meet all of the requirements of Montgomery County's zoning ordinance.
And tell me what you base that figure on?
Well, that is in the county's impact report, which is based on their own records, I presume.
You say the county has supplied that number?
Let me review, please.
Sure.
And Your Honor, if I may, just to help, Mr. Boswell referenced a industry report before, and that is attached to his rebuttal testimony as attachment 2.
Mr. Sheehan, do you have attachment 2 to the rebuttal testimony?
I do not have his attachment 2 handy, no. I don't need to see it, Your Honor, at this point, if that's what you were thinking.
I'm looking here at the impact report of the Montgomery County Solar Collection Systems in the AR zone. It identifies 2 projects, Riggs Road Free Range Solar and Gregg Road Solar, which have been permitted and approved under the zoning text amendment.
That's the number of projects that have been approved, right?
Yes.
What makes you think that is the total number of projects that could be approved if there were applications?
Well, what I argued was that this was our estimate of what would be viable, which applies a number of factors beyond just which parcels strictly qualify on the basis of not having Class 1 or Class 2 soils on them, which include proximity to capacity on the grid, limited environmental obstacles such as wetlands. So I'm not suggesting that those are the only parcels which meet those requirements, but that in the years since that zoning text amendment was passed, which has been close to 5 years, only 2 projects have come to fruition.
Yeah, are you aware that many projects have not come to fruition because of difficulties with connections?
I'm aware of the assertion in Ms. Taylor's testimony. I think that assertion is perhaps based on some inaccurate understanding of how the grid functions.
Please explain that.
Well, Ms. Taylor's testimony alleges that the PJM interconnection queue is the primary obstacle for connection of community solar projects. At the size of 2 megawatts and even the 3 megawatts and larger that we're discussing, those projects are connected to the distribution grid, which at this point in Maryland has no real interaction with the PJM interconnection queue.
But isn't it true that there are projects that have been, there are applications for projects in the pipeline that have been held up because of the connection issue?
It is possible that some other developers have had issues getting capacity on the PEPCO, BGE, or Potomac Edison grid. However, that's not the case with the Ramiere project.
No, I understand it's not with Ramiere. But do you have any reason to doubt Ms. Caroline's testimony that some 15 other projects have been held up because of connection issues?
I have no way to verify that.
Okay. With respect to your testimony that there is, quote, limited ability for Montgomery County solar projects to contribute to the state's solar energy requirements, did you see the testimony from Ms. Taylor in her rebuttal where she said, quote, Montgomery County ranks 2nd out of Maryland's 24 counties in solar energy output?
I did see that.
Okay. And you saw her testimony that Montgomery County is the first local government in Maryland to be recognized with a Platinum Designation 5, the highest level awarded for encouraging the growth of affordable solar energy options at the local level. You saw that?
I did see that.
Yeah, good. Are you aware that that her testimony also states that Montgomery County mapping shows over 8,200 acres of warehouse and parking areas that could host solar facilities? Did you see that?
Yes, I did.
Do you have any reason to doubt that figure?
I haven't done the analysis myself, but I don't doubt it.
Okay. Are any of Chaberton's 150 projects on rooftops?
Well, to be clear, not all of those are operational. Those are opportunities. But yes, we do have at least one rooftop opportunity.
At least one.
Yes.
Yeah.
It's relatively small in size. It's about 150 kilowatts.
Yeah. At least one. Can you think of any others?
We have some projects in development on rooftops, but they're not currently operating.
Okay. Out of the 140 projects in the pipeline, how many are on brownfield sites?
None that I can recall.
Are there any other projects that are on surfaces that are not farmland?
We have a couple of projects that have been permitted to be floating on lagoons, but those projects have not been constructed.
I'm sorry, I didn't understand that.
We have some projects which are floating solar projects that
Floating?
are, yes, correct. They're designed to float suspended on a wastewater pond, for example, or any other body of water.
Thank you. Mr. Boswell, are you aware that that Ms. Taylor has testified that the going lease rate for farmland in the agricultural reserve is $120 a year?
I am.
Do you have any reason to doubt her?
I do not.
Are you aware that your website says that Chaberton offers farmers $40,000 to $200,000 a year?
I haven't seen that, but I don't have any reason to doubt it.
Do you have any reason to doubt Ms. Taylor's testimony on rebuttal that 60% of farming in Montgomery County is conducted on leased land?
No, I don't.
You said in your testimony that the Ramiere project will serve, quote, low and moderate income consumers in Montgomery County, right?
Correct.
How many consumers are you talking about?
For the Sugarloaf project, 40% of its subscribers must be low to moderate income, and so that would be approximately 250 households.
That's for Sugarloaf, and now we're Ramiere.
Yeah, for Ramiere, it doesn't have the same LMI requirement. However, that doesn't prevent any LMI households from subscribing.
So how many consumers are you talking about?
I can't speculate on that. It would be in total perhaps 500 subscribers, but it doesn't have the same statutory requirement to have 40% LMI.
500 subscribers. And how many of them are low-income consumers?
As I said, I can't speculate on that. The project hasn't been subscribed, and it doesn't have a statutory requirement to be subscribed to low to moderate income households.
What's a low-income consumer? What's that mean?
I don't know the definition off the top of my head. I believe it's 80% of area gross income.
What's a moderate income consumer?
I don't know the definition, sir.
So you say the project will serve low and moderate income consumers, but you're not exactly sure what those terms mean, and you're not exactly sure how many consumers you're talking about. Is that fair to say?
I am not responsible for directly subscribing subscribers to our project, so that is correct. I'm not familiar with the definitions there.
You also say in your testimony that Chaberton is an industry leader in projects that, quote, create well-paying jobs, close quote. If the project is approved and it gets constructed and then it operates, how many local jobs, by which I mean jobs in Montgomery County, not held by Chaberton employees, how many jobs will the project create?
I believe our JEDI report says that the project will create 42 jobs.
And what will those employees do, those 42 employees on this 11-acre plot?
The majority of those would be created during the construction of the project.
No. I meant to say after the project is up and running.
Those jobs would pertain to operations and maintenance, so those jobs would be for electricians. In the absence of sheep to maintain the vegetation, then there may be some vegetative maintenance performed by a human, but primarily those are maintenance jobs.
So those are 2 or 3 or 4, not 42.
That's right.
Mr. Boswell, where does Chaberton get its solar panels from?
We actually generally don't procure the panels. That is left up to the owner-operator.
But you designed the project, correct?
Yes, we do, up to a point.
What point is that?
We refer to it as a 30% design, so it is a constructible design, but none of the physical materials have been procured.
Does your 30% design include specifying the solar panels?
We do specify a module, but it is not necessarily what will be constructed. Again, that decision is left up to the owner-operator.
And the panels that you include in your 30% design, they are installed horizontally above the field, am I right?
They are elevated above the field, yes.
And they're horizontal?
In the case of Ramiere, they're on I think, 25-degree tilt, so not precisely horizontal or vertical.
Okay, they're not vertical.
Correct.
Okay. So in April, we talked about vertical panels, and I asked you why Chaberton didn't use vertical panels. Do you remember that testimony, that discussion?
Yes, I do.
Has Chaberton done anything since April to investigate the suitability of vertical solar panels in farmland?
I'm not aware of any investigation into vertical solar panels.
In April, you said that Chaberton didn't consider vertical panels because they were not yet common in the industry and you couldn't get financing for them. Do you recall that testimony?
That is one concern, yes.
Okay. What's another?
Well, that's the primary concern, but generally it stands to reason that the amount of energy produced on the same amount of land with a vertical approach, if it were, for example, around the perimeter of a fence line, would not be, you would not generate as much electricity, both because of the orientation of the panels, but because of the density of the panels as well.
So Chaberton has done some homework about vertical panels.
Yeah, we have not done further investigation since April, which I believe was your question.
Yeah, good, good. Yes, the Sugarloaf hearing. Yes, yes, ma'am. Yes, ma'am. Mr. Boswell, is it fair to say that the community that the Sugarloaf and Ramiere projects will serve is Montgomery County?
The project is, in the case of Ramiere, designed to serve any ratepayer in PEPCO territory, but we would like to prioritize Montgomery County residents.
And that's true of Sugarloaf, Montgomery County, correct?
It would be designed to serve Potomac Edison customers, so within Montgomery County or outside Montgomery County, as long as they are in the service territory of the distribution utility.
Isn't it safe to say that the majority of those customers are going to be in Montgomery County?
I, again, don't have responsibilities over subscribing customers, but in PEPCO territory in particular, yes, they're likely to be in Montgomery County.
Your website says that Chaberton names its projects after mountain peaks. Is that correct? Is that
I'm
correct?
sorry, yes.
Yeah. And then it says it does that, quote, to recall the beauty of nature and the pristine environments we are working to preserve, close quote. Do you recall that from your website?
That sounds like our website, yes.
Would you agree with me that that statement is inconsistent with putting industrial solar panels on prime farmland?
I do not.
Will you tell me why you think those two statements are consistent?
Well, we believe that clean energy contributes to preserving the environment, and so yeah, I don't agree with that characterization.
Okay. And in your testimony in this proceeding, you said at page 3, quote, Chaberton Energy deeply values the community. I'll try to speak up.
Can you try turning it back on?
Now it's off. Now it's on. Shall I
Sorry
try
about that.
again?
Sure.
Okay. I'm going to start again, Mr. Boswell. In your testimony, you say, quote, Chaberton Energy deeply values the communities it serves. Correct?
I did say that.
And your website says exactly the same thing. We deeply value the communities we serve. Is that accurate?
That is correct.
Okay. Chaberton was aware of the Montgomery County zoning laws when it put in its application for Ramiere, didn't it?
Yes.
And it knew that its application would violate, it knew that the project would violate Montgomery County zoning laws, and that's why it seeks permission from the Public Service Commission to override those zoning laws. Am I right?
No, I wouldn't characterize it that way. The projects over 2 megawatts are subject to the jurisdiction of the Public Service Commission, not necessarily the local authority.
All right. But you are asking the Public Service Commission to override Montgomery County zoning laws, are you not?
We are asking them to exercise their authority under the law, yes.
You're asking them to exercise their authority under the law to override Montgomery County zoning laws, correct?
We are asking them to use their preemptive authority on citing this project, which does conflict with Montgomery County zoning laws.
So was that a yes answer to my question?
I'm not sure I really understand the substance of the question. We are here before the Public Service Commission because state law requires that a project of this size be reviewed and, if we're fortunate, approved to be cited within the state of Maryland.
Okay, let me ask it again simply. Are you asking the Public Service Commission to override Montgomery County zoning laws?
Your Honor, I apologize. I'm going to object here. I believe this has been asked and answered already by Mr. Boswell.
It has been asked and answered.
It's been asked and answered?
Yes, sir.
Okay. Mr. Boswell, in the Sugarloaf proceeding, you testified that you were aware that the agricultural reserve was established in 1980, and you knew that the reserve is celebrated across the nation as a model for the preservation of open space and farmland and adjacent farmland. Have I accurately described your testimony in the Sugarloaf case?
I have read the history of the Montgomery County Ag Reserve, yes.
Have I accurately described your testimony in the Sugarloaf case?
I don't have my testimony in the Sugarloaf case in front of me, sir.
Okay, well, then I'll ask you again. Are you aware the agricultural reserve was established in 1980?
I am.
Okay. And you knew when the Ramiere Chaberton knew when the Ramiere application was put in that the reserve is celebrated across the nation as a model for the preservation of open space and adjacent farmland.
Yes, I'm aware of that.
Mr. Boswell, you're aware that at public hearings on the Ramiere application, a number of Montgomery County residents appeared and opposed the application. You're aware of that, are you not?
I am.
And you know that my clients, the Montgomery Countryside Alliance, the Sugarloaf Citizens Association, the Montgomery County Farm Bureau, and the Montgomery Agricultural Producers, all of whom represent community interests, oppose this project. You're aware of that, are you not?
I am aware.
Yeah. Thank you, Mr. Boswell. That's all I have.
Thank you.
Any redirect?
Excuse me, Your Honor. Yes, just a few quick questions,
Go ahead.
please. Thank you. Mr. Boswell, first thing, can I ask you, please, to turn to your direct testimony at page 6?
Okay.
Okay, and do you remember when Mr. Sheehan was asking you before about your statement? I believe it's on line 10 here regarding the limited ability for county-sited solar projects to contribute meaningfully to the state's solar energy requirements.
I do.
Do you remember that?
I do remember that.
Can I please get you to read line 4 here, starting at the final report?
The final report from Maryland's task force to study solar incentives, published in April 2024 and attached to my testimony as Appendix C, estimates that up to 35,000 acres of land, a large portion of which will be farmland, will be needed to achieve the state's current RPS requirement to generate at least 14.5% of its electricity from solar sources by 2030.
Thank you, Mr. Boswell. And so was your testimony here regarding your concern about the county's ability to contribute to meeting those solar energy requirements was that related to the difficulty in siting solar in the Montgomery County Agricultural Reserve?
Yeah, it's directly related to the restrictive nature of the zoning in the agricultural reserve.
Okay, and Mr. Boswell, do you remember when Mr. Sheenan was asking you before about Ms. Taylor's, I believe it was her rebuttal testimony, where she referenced, I think, that Montgomery County has the second highest amount of solar of any county in Maryland?
I do recall that, yep.
And I think there was a number mentioned in there. It's about, at least at the time, it was 100, maybe 187 megawatts.
That's right.
Do you have any idea, would those include like residential rooftop solar?
Yes, that includes a significant amount of residential rooftop solar.
Okay. Thank you. The other thing I wanted to ask you, you also heard some questions from Mr. Sheehan, again relating to Ms. Taylor's, I think, rebuttal testimony about various figures regarding the number of acres available of land that would potentially accommodate solar in the Montgomery County Agricultural Reserve while still meeting the ZTA requirements. Do you remember that?
I do.
And do you remember also asking Mr. Sheehan asked you some questions as well about similar numbers for like rooftop space and parking lots?
Yes, I do.
Okay, and do you are you aware? Did those analyses consider whether any of those landowners would be willing to lease any of that space for solar development?
It doesn't appear to account for owners' willingness to participate in a project.
Okay, and does the applicant here, Chaberton Solar Ramiere LLC, does the applicant have condemnation authority?
We do not.
And are you seeking condemnation authority?
We are not.
Thank you. Just one more question. Do you remember, I think at the very beginning of your discussion with Mr. Sheehan, you were talking about agrivoltaics. I believe Mr. Sheehan asked you a question along the lines of what might happen if the applicant is unsuccessful in getting a substantive response to the RFP to implement agrivoltaics should this project be approved. Do you remember that?
I do.
Is it your understanding that what may or may not be required with respect to agrivoltaics may be set out in a licensing condition should a CPCN be issued?
I would expect that the license conditions would clarify the requirements around agrivoltaics.
And potentially those licensing conditions might also direct Chaberton to further action should it not be able to obtain a viable agrivoltaics partner?
I would expect that to be the case, yes.
Thank you. No more questions, Your Honor.
Your Honor, can I ask one question more?
Sure.
Have you released the RFP to the public, and if not, why not?
We have circulated it to some members of the public. We haven't circulated widely because we're not currently looking for a vendor. We tend to start those negotiations after a project's been approved.
I was going to do follow-ups, but I don't want to test your honor.
Go ahead, do your follow-up.
To whom did you circulate it?
I wasn't directly responsible for that, so I'm not sure I can recall precisely, but as you mentioned in your questioning, the Maryland Beekeepers Association did review the RFP. We reviewed the RFP with the Office of Agriculture in Montgomery County, which provided some great feedback. And
did you get any other responses?
we didn't get responses seeking to provide services, if that's your question.
So when will you release it to the public?
Once the project is approved, we'll release the RFP. I should clarify, if the project is approved and granted CPCN.
Why will you wait until then when you'd learned so much by releasing it now? The public interest would be served by releasing it now so we could know whether you're actually going to get any responses to it before the project is approved.
Well, we understand that it's harvest season and farmers are very busy, and we don't think it's wise to waste their time this time of year.
I don't have any more questions. Thank you, Your Honor.
Do you have any redirect?
No, thank you, Your Honor.
Okay. Can you describe the property, the Ramiere property?
Yeah, it's 116 acres in the agricultural reserve off Whites Ferry Road near Poolsville.
Okay. Is it currently being farmed?
It is, to the best of my knowledge, yes.
Okay. Now, we've been referring to the Sugarloaf project. Can you describe that?
I don't know the total size of that project off the top of my head. It's, I think, roughly the same size. Well, maybe smaller in that case. It's several adjacent parcels there. That one is in the Ag Reserve on Darnestown Road.
And how far apart are these two proposed projects?
They're, I would guess, several miles apart. I don't know the precise number.
Would you think I'd be wrong if I said they were less than 8 miles apart?
That sounds reasonable.
Okay. Now, this project, the proposal, the life of the project is 22 years. Is that correct?
The length of the base lease is 22 years, but the project would be expected to operate at least 35 years, perhaps 40.
Okay. There was a agrivoltaics plan and draft RFP submitted to Park and Planning before its April meeting. Is that correct?
That's correct.
Are those anywhere in the record in this case?
Your Honor, I think I might be able to answer that. I think the answer to that is no at this point.
What is the plan? What is Chaberton's plan for agrivoltaics at this point?
If the project were granted a CPCN, we would probably revise our RFP or at least revisit it before releasing it to the public. We have, as I mentioned, a handful of contacts that are providing these services to other solar developers or solar owner-operators. We would provide the RFP to them and look for feedback on how we might make this an effective agrivoltaics project.
What type of agrivoltaics providers are sought in the RFP?
Well, what our consultant Okavate recommended were either grazing of livestock. They specifically recommended sheep. They also recommended an aviary and potentially integrating the two. But I think we remain open to any kind of solution that is attractive to a provider.
Does any part of the RFP seek like low-level ground crops?
It did. The RFP itself does not necessarily seek ground cover or ground crops, as far as I'm aware. Based on the recommendations of Okavate, they did not think that vegetative crop would be viable given the tightness of the row spacing at Ramiere.
PPRP's conditions require, I can turn to the right page, that the project owner file a final agrivoltaics plan reviewed by Montgomery County to the PSC docket at least 30 days prior to operation. What does that condition mean to you?
My understanding of that condition is that if we are going to elect to pursue agrivoltaics, that they would like to see that Montgomery County Office of Agriculture has reviewed our plan, presumably also provided feedback, but it doesn't seem to go as far as requiring the approval of the Office of Agriculture.
So you use that word again, if we decide to pursue an agrivoltaics plan. The letter from Park and Planning seems to indicate that there was a commitment to provide agrivoltaics as a part of this CPCN. So which is it?
We are committed to it. I use the word if because we have not been granted a CPCN at this point.
Okay, well, PPRP Condition 17, agrivoltaics plan, says if agrivoltaics is employed at the project site, the project owner shall, and then continues. So what happens if you get a CPCN and then for some reason agrivoltaics are not an option?
I believe that we would still continue to pursue the project. We think the value of solar on its own is extremely valuable. Those benefits have been articulated in our ERD, but I can't do more than give my word here that agrivoltaics is something we are committed to and that we intend to pursue in this project.
So the park and planning conditions were filed on May 15th. Subsequent to that, you filed a settlement status update indicating that Chaberton would not object to the conditions of PPRP and staff, but the conditions of park and planning weren't mentioned at that time. But then later in your rebuttal testimony at page 2, you say the applicant will not contest the licensing conditions proposed by the planning board in its comments filed May 15th. In its comments, there's a letter and then there's an attachment. Which set of conditions is Chaberton agreeing to?
If I may review it, Your Honor. I don't believe I have that planning board recommendation in front of me.
Okay, well, there, in the,
Your Honor, I think I may be able to point to Mr. Boswell where it's available in his binder.
sure,
If I may.
go ahead. You can approach the witness if you want.
Mr. Boswell, if you turn to, and it's tab 20 in your binder.
Okay, I'm seeing the Montgomery County Planning Board letter here. Reviewing the planning board's conditions. We don't object to complying with those conditions.
You're talking about conditions 1 and 2 at the bottom of the May 13th letter from the Montgomery County Planning Board, is that correct?
That is correct.
Is Chaberton agreeing to a 10-foot wide bikeable shoulder?
We did not agree to that.
Okay, so looking at those conditions of the Montgomery County Planning Board in the May 13th letter, the first condition is the applicant must implement agrivoltaics on the property in a manner capable of being enforced by the Public Service Commission and coordinate this activity with the Montgomery County Office of Agriculture. What does that mean to you?
I don't know what the planning board had in mind when they described it as in a manner capable of being enforced by the Public Service Commission. I can speculate, but I'm not sure that that'd be valuable.
There, Chaberton's proposing a 30-foot wide vegetated landscape buffer on the north and the east. Is that correct?
That is correct.
How many residences and or roads can see the proposed project from there?
On the east side, I believe there's one residence that's about 1,800 feet away, so it would have pretty low visibility. To the north, I believe the nearest residence is much farther.
To the south and the west, Chaberton is proposing using existing vegetation and a 7-foot security fence to buffer views. Is that right?
That is correct.
The project, the land is described as hilly, not, big hilly, but a little bit hilly. Does the slope contribute to the visual impact to those nearby residences?
Not so much the nearby residences. The public right-of-way, Whites Ferry Road, it is difficult to see where the array will be placed because it slopes away from the road.
At at some point, Chaberton was going to follow up with the Montgomery County Fire Department about ground nesting bird seasons and mowing. Was that follow-up accomplished?
I am not aware whether that coordination has happened or not. I'm happy to respond to a data request.
Are you the appropriate person to talk to about decommissioning?
I believe that would be Charles Walker of Arm Group.
So, in Chaberton's opinion, if the only type of agrivoltaics that can be accomplished are essentially ecovoltaics, beekeeping and ground pollinator habitat, would that comply with Park and Planning's condition that there be agrivoltaics on this property?
The Montgomery County zoning code did describe agrivoltaics as apiaries and pollinator habitat. We would like to do something more robust than that, but we rely on the expertise of our vendors to provide those solutions.
Okay. Water for large animal grazing was addressed. What is the outcome of those conversations?
I think that solution would be provided on an individual basis depending on the vendor, but likely would either require a well to be drilled on site or for water to be trucked in.
There are 5 conservation easements on this property, am I right?
That sounds accurate.
Can you describe those to me?
One moment, please. I'm not finding that the answer there to be readily available. I know that there's a forest conservation easement currently on the property, but I'd be happy to provide more information in response to a bench data request.
Okay, thank you. Does anyone have any questions based on my questions?
No, Your Honor.
Your Honor, may I suggest that the RFP be made part of the record?
Chaberton?
I think that's certainly something I could discuss with the applicant, Your Honor. I guess just the one thing I'd like to say is, I mean, this case has been going on for a long time, and they've had the opportunity to ask discovery and request that information, and it never was requested. But if Your Honor believes it would be helpful, though, for purposes of the record, I think we could do that pending
I think I'll ask that be filed along with the agrivoltaics proposal that was sent to Parks and Planning prior to their April meeting.
Okay.
And that'll be admitted as bench data request 1. I have no further questions for you. Thank you for your appearance.
Thanks, Your Honor.
Your Honor, if I may, PPRP's project manager said that that's already been filed in response to one of PPRP's data requests, and that would probably be Appendix A to the project assessment report that I'll be marking for identification later today.
I have that. I have Appendix A right here.
but see if we can get you a better site for that, Your Honor.
Yeah. Uh, Was it the Okavate report?
It's not farming request for proposal. It was the same document that was
Okay, I have that. That's data. It's available in Power Plant Research Program Data Request 4-8. And it's already in the record.
That must be where I saw it. Thank you, Your Honor.
Yeah, it's already in the record. Thank you.
You had something else, though, that you mentioned.
They're both there.
Ah, good.
And, Your Honor, I apologize, just where we were talking about bench data requests, I understand you may want to address it later, but would you like us to provide some additional information based on your questions?
You know, I don't need that information. It's in an attachment. I just wanted a more clear description of it that's quotable in an order.
Okay. And would you like any on the conservation easements?
No, that's okay.
Okay. Thank you, Your Honor.
Thank you. Another witness for Chaberton?
Yes, please, Your Honor. Your Honor, at this time, the applicant would like to call Mr. Charles Walker.
Good morning. Please raise your right hand. Do you swear or affirm under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth of the testimony that you're about to give?
I do.
And could you please state and spell your first and last name for the record?
Yes, it's Charles Walker, C-H-A-R-L-E-S, W-A-L-K-E-R.
And could you provide your business address?
Yes, it's Arm Group, and we're located at 9175 Guilford Road, Suite 310, in Columbia, Maryland, 21046.
Thank you, Your Honor. Good morning, Mr. Walker.
Morning.
Could you please state your position with the ARM Group, please?
Yes, I'm a project manager with Arm Group.
And could you please provide a brief description of your educational background?
Yes, I have my bachelor's in civil engineering from Virginia Tech and graduated in 2017.
Thank you. And could you please describe your prior work experience?
Mm-hmm. So I've been working in civil engineering and land development industry for 8 years. Have my professional engineer's license, had that for a couple years now, and then have a lot of experience in solar and CPCN projects throughout Maryland. I've testified on numerous CPCN projects here. Yeah.
And Mr. Walker, when you say that you're a licensed professional engineer, is that in Maryland?
Maryland and Virginia, yes.
And Virginia, okay, thank you. And Mr. Walker, are you familiar with the direct testimony of Andrew Reese that was filed on August 16th, 2024 under mail log number 311749?
Yes.
And is your purpose here today to adopt Mr. Reese's testimony?
Yes, it is.
And Mr. Walker, if I asked you the same questions appearing in that document here today, would you provide the same or substantially similar answers?
Yes, I would.
Okay. And this is probably obvious, but and you're familiar. Are you familiar with the applicant's proposed project here?
Yes.
Okay. And Your Honor, I'd like to ask that the direct testimony of Andrew Reese, filed on August 16th, 2024, under mail log number 311749, as adopted by Mr. Walker, be marked for identification as applicant exhibit 41.
So we're going to mark it as applicant exhibit
43. Okay.
And it is so marked. Any objections to the omission of 43?
No objections, Your Honor.
Submitted as well.
Thank you, Your Honor.
Prospect PPRP?
No cross.
Montgomery County?
No.
Staff?
No cross.
Parks and Planning?
No, Your Honor.
Interveners?
No, thank you, Your Honor.
I have questions.
All right.
So, tell me what other cases you've testified on here in Maryland? Any recently?
I don't have the list right in front of me, but yes, it's been several recently.
The latest decommissioning plan, and I think it's called the final decommissioning plan that I'm supposed to be referring to was filed on March 21st, is that right?
Yes.
Okay. The 2% inflation is calculated each year for 5 years. Why not the life of the project?
Because the decommissioning estimate is required to be revisited and updated every 5 years. So we just did for the first 5 years, and then in 5 years after that, it'll be updated.
Okay. Which landfill was used for the calculation?
I might have that in front of me. It's the nearest landfill in Montgomery County, but I don't know if I have the exact name.
It's not. I turned it off because I was coughing. I apologize. Keep me honest.
I don't believe I have that, the name of the landfill.
Okay. The nearest landfill does not accept recycled panels, and that's why there's a different travel, hauling, and loading cost to Sparta, Tennessee. Is that correct?
I believe we included that cost to be conservative just in case they don't accept panels. When we called and talked to the landfill, they said they do accept panels, but we did that to be conservative.
So the total bond amount that's being recommended is $660,225 for this project. Is that correct?
Yes.
Does that include any salvage or resale?
It does not.
And what about a contingency cost?
It does not have a strict contingency cost. It does have a 10% contractor profit, which could be considered contingency in a way, but not a specific contingency cost.
In your testimony in other cases recently here in Maryland, was there a contingency cost?
Yes, contingency cost up to 25% was recommended on recent cases.
Give me just a moment, please. All right, I don't have any further questions. Does anyone else have any questions based on my questions?
No, Your Honor.
No, Your Honor.
Thank you for your appearance today.
Thank you.
Mr. Flavin,
Your Honor, that concludes the applicant's witnesses.
PPRP,
Good morning, Your Honor.
good morning.
I'd like to start off, as Mr. Flavin did, with identifying the exhibits the PPRP has. There are 8 exhibits. All of them were filed on May 15th, 2025, and all of them were filed under mail log number 318870. PPRP Exhibit 1 for identification is the direct testimony of Supita Pikau. PPRP Exhibit number 2 is a secretarial letter signed by the Secretaries of the Maryland Department of Natural Resources and the Maryland Department of the Environment. PPRP Exhibit number 3 for identification is PPRP's initial recommended license conditions. PPRP Exhibit 4 is the project assessment report. PPRP Exhibit 5 for identification is Appendix 8 to the project assessment report, and that consists of the applicant's responses to selected PPRP data requests. PPRP Exhibit 6 for identification is Appendix B to the project assessment report, and that is PPRP's glare analysis. PPRP Exhibit 7 for identification is Appendix C to the PAR, which is an environmental justice EJ screen report. And finally, PPRP Exhibit 8 for identification is Appendix D to the PAR, and that is reference sections of PPRP's website. We would like at this time to move for admission of Exhibits 2 through 8 into the record, and I'll address Exhibit 1 when Ms. Pekow takes the stand.
Any objection to PPRP Exhibits 2 through 8?
No objection.
2 through 8 are admitted.
All right, and at this time, I'd like to call Ms. Pekow to the stand and have her sworn.
Thank you.
Raise your right hand. Do you swear or affirm under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth, and the testimony that you're about to give?
I do.
Could you please state and spell your first and last name for the record?
Supida Pukal, Supida, Piwkhoww.
And could you provide your business address?
Department of Natural Resources, 550 Taylor Avenue, Annapolis, Maryland.
Your witness.
Thank you. Ms. Pekow, do you have in front of you what has been marked as PPRP Exhibit 1 for identification, which is your direct testimony, which was filed on May 15th, 2025?
I do.
Do you have any corrections to make to this testimony at this time?
I do. I have a correction on page 27 of my testimony, line number 1.
Hang on 1 second. Okay, go.
Page 27, Your Honor.
I'm there.
Line number 1. I like to correct the word minority and replace it with low income.
Thank you.
Thank you, Your Honor.
Do you have any other corrections to make?
No, I don't.
Was this testimony prepared by you or under your supervision?
It was.
Is it true and correct to the best of your knowledge?
It is.
And if you're testifying on these issues today, would your answers be the same?
Yes.
Your Honor, at this time, I'd like to move for admission of PPRP Exhibit 1.
Any objection?
No, Your Honor. And with that, I'll tender the witness.
Any cross-examination from Montgomery County? Staff?
No cross from staff.
Park and Planning?
No, Your Honor.
The interveners?
No, Your Honor.
Chaberton?
No, thank you, Your Honor.
What is PPRP's recommendation in this case?
The secretaries of MDE and DNR recommend approval of the project, Your Honor.
So I'm looking at the secretarial letter, and it doesn't actually say recommend approval anywhere in that letter. It says, enclosing our preliminary recommendations, it says, based on our review of the application and associated environmental information available to date, we have concluded that the construction and operation plans submitted meet all applicable cultural and environmental regulations provided that the attached recommendations are incorporated as conditions to the CPCN. But I can take your testimony to be that PPRP's recommendation is that it be approved?
Yes, Your Honor.
Okay. Does Montgomery County have decommissioning regulations?
No, there's no specific requirement regarding the decommissioning from the county zoning.
Okay. You participate in a lot of CPCNs in Maryland, right?
That's correct, Your Honor.
These conditions were issued in May, and I think decommissioning conditions have come a long way since then. Did PPRP consider revising their conditions?
From my understanding, the content does not change much because these projects, the content has been updated with the more recent update. Although the wording might be tweaked more recently with the recent project that are filed, but then the key point is that PPRP recommend a licensing condition requiring the applicant to submit pre-construction decommissioning plan prior to construction, and then it may be subject to an evidentiary hearing before the commission.
Does PPRP believe that the recommended bond amount of $660,225 is sufficient?
It is, Your Honor, and I may note that typically PPRP does not recommend contingency on the project does not account for salvage value unless it is required by the county. So, and in general, there will always be revenue from recycling to cover the cost. So this is conservative enough from our assessment, but adding the contingency on top of that would be very conservative. That's the reason why we typically do not recommend additional 25% contingency unless it is required by the county.
Okay. Your testimony says that you compared this amount with other cases with similarly sized projects. Do you recall which cases you compared it to?
I can give you the case number and the amount, Your Honor. I can refer to case 9746, Pleasant Valley, 2.14 megawatt. The recommended bonding amount is $507,550. Another project is Orchard Hill, case 9739. That is 2.24 megawatt. The recommended bonding amount is $616,679. And the last one is 9725 Pine Rock. That is 3 megawatt. $709,678 or 76. Sorry, I have typo on my last digit. And those the figure that I refer here is on the final order of those projects.
Okay, thank you. So the recommended license conditions for agrivoltaics start with if. What does PPRP intend?
The intention was that we does not oppose the county requirements regarding agrivoltaic, but in the past case, agrivoltaics is already recommended in the licensing condition for the project that are co-locating with another project on adjacent or the same property with the total capacity greater than 5 megawatt as required by the public utility articles. I can cite that articles. That's why what I would state is that it's beyond the authority for the reviewing stage agency to recommend something that we don't have the power to. It is Public Utility Articles 7-306 2D13I. It is prohibited co-location of community solar on the same or adjacent parcel, and then below that there was some requirements that if that were to happen, agrivoltaic is part of the solutions.
So is it PPRP's position that even if agrivoltaics is not utilized on this project, that PPRP is still recommending approval?
Yes.
Okay. In the PAR, and I apologize, I don't have a page citation. It states vegetation management, and then it says for site stabilization where agrivoltaics were not employed. Does that mean where agrivoltaics are not employed at all, or does that mean in areas surrounding where agrivoltaics is employed?
It's been the areas surrounding the area where agrivoltaic is employed. I think the applicant cited the arable area within that LOD is 7 acres. It's meant for the remaining acreage that is not being used for agrivoltaic. That there's the opportunity to employ those vegetation management.
Okay. The glare reports indicate that there's going to be some glare on, well, it says 16.2 hours of yellow glare to one residence to the south and 21 hours of yellow glare to a driveway to the south. Is that the same residence and driveway?
Yes, Your Honor, it's on the same location.
And then also some green glare. And is that the same?
No, green glare was detected in other stationary receptors.
Okay, and that glare analysis is conducted at year 3, is that correct?
At year 3 of planting.
So the plantings are, the area where there's yellow glare, the plantings are proposed to be at 6 foot at planting, is that correct?
I can, give me 1 second. I have
Sure.
that on my testimony, the proposed planting. That's correct, Your Honor. My testimony, page 23, line 3, referenced information provided by the applicant that the buffer will be 6 feet tall at installation.
So at year 3, do you know how tall they're proposed to be?
I believe it's about 12 feet.
I recall that as well, so maybe we're both right. So does PPRP find those hours of yellow glare acceptable?
I would like to point out before I conclude that we simulate 2 scenarios on the glare analysis. Scenario 1 is with the proposed buffer on the east and the north. That's when the yellow glare are detected. The second scenario mentioned here is that the first scenario was conservative because that's the proposed buffer that the applicant having a sole control of. However, the second scenario that we analyzed, on the southern side of the LOD, there's another existing row of vegetation that in the second simulation, PPRP account for those vegetation that are existed on the site, and those glare no longer detected.
On the second
Scenario.
On the second scenario, on which side of the LOD?
The southern side of the LOD, Your Honor. And after doing that, we no longer detect yellow glare on the stationary receptor and the driveway adjacent to that stationary receptor.
If there's glare, so assuming for the sake of argument that there's yellow glare on a nearby residence, at year 3, there would obviously be glare, and it might even be greater at year 1 or at construction, right, after construction. What is PPRP's proposal for conflict resolution?
May I clarify your question?
Go ahead,
because are you talking about this receptor that would experience yellow glare, or are you talking about all other receptors that would experience any glare at all? Or that particular?
We'll just go with a simpler question. Regarding conflict resolution to neighboring properties, what's PPRP's proposal?
PPRP conclude that the proposed buffer that the applicant proposed for the project on the northern and eastern sides are sufficient to mitigate the glare.
Okay, what about other complaints?
Other complaints, the noise, that...
Any types of complaints?
Any type of complaint.
Does PPRP have a conflict resolution condition?
Yes, PPRP has a complaint resolution recommended licensing condition that describe the process of how...
Okay, and what is that process?
That the applicant... give me 1 second, Your Honor, sorry. It's condition number 7.
Go ahead.
The project owner shall provide the PSC with a copy of the complaint and its response to the complaint within 45 days of receipt. And then the project owner's response to any written complaint shall clearly inform the aggrieved party that if not satisfied with the project owner's response, the aggrieved party may seek relief by filing a complaint with the PSC. And then just any change in the representative's contact information shall be updated on the site within 45 days. And that complaints include, but not limited to, reflective glare, visibility of structures within the LOC, health of vegetative buffer, fugitive dust, road damage, or noise.
Excuse me, Your Honor, and if I may mention, recommended licensing condition 32 is an omnibus compliance thing that covers after the CPCN is issued, and it provides further a further method for bringing a complaint to the Commission's attention.
Okay, thank you. Did you hear the testimony of Chaberton's witness that it may be possible for water to be, or it may be necessary for water to be trucked in, or for a well to be dug for grazing agrivoltaics?
For grazing, well, I do not have, I'm not aware of the amount that would be required for cheap grazing, but I believe for 100 acres, it seemed to be, it will need a big herd. So there was some discussion or question in other site, and seemed like some other project that trucked in the water that will be fed to the sheep. But for the well, they just have to follow the MDE permitting process if it will be needed.
So the wording in the conditions as they are covers any extra permitting that would be required for the digging of a well?
I believe we have the condition about dewatering and also like in the agrivoltaic plant, if agrivoltaic were to be employed, and on condition number 17B3, we require that the applicant address that. Seventeen B3.
So I'm glad you pointed to that, because this is a condition that requires, if agrivoltaics is employed, that the project owner shall file a final agrivoltaics plan reviewed by Montgomery County. What does that mean, reviewed by Montgomery County?
At least they should get have submitted to Montgomery County Department of Agriculture and have them review. PPRP has no information whether the county has the authority or will, or what's the process of the approval or review at the county level. And I believe there was the witness from County Department of Agriculture, not witness, but representative from County Department of Agriculture participate at the third public hearing, and I believe the representative has said they still unsure about the process.
Okay, thank you.
You're
So you were pointing me to 17B3, and this is not the new agrivoltaics plan that needs to be submitted at that time. It says, when applicable, how the project owner will implement adequate water infrastructure, working wells, irrigation system, or water supply to support the use of the property for both solar power generation and the agrivoltaic activities selected for the project site. So if they run a plan by Montgomery County, even without approval, and then file that in the docket at least 30 days prior to operation, that's sufficient for PPRP?
I believe that is sufficient, Your Honor.
Okay, so what happens? I'll take that question back. I don't have any further questions for this witness. Does anyone have redirect?
No redirect, Your Honor.
No, Your
Go ahead.
I'd like to ask a question or two. Ms. Picow, the PPRP document that we've been talking about sets a condition of agrivoltaics, does it not?
Yes, I'm aware that we discussed the condition about the agrivoltaic,
Yeah.
especially from the
Yeah.
MNC PPC conditions.
Right. That document does not say that PPRP would recommend approval of this application if there were no agrivoltaics. Am I correct?
Could you repeat your questions again?
That document does not say that if there were no agrivoltaics, PPR would still recommend approval of the project. Am I right?
First of all, PPRP does not have the authority to recommend approval. It's coming from the secretaries of MDE and DNR. And that it is the documentation was part of the document that was approved, including the package that was approved by the secretaries.
But I thought you testified a moment ago that PPRP would approve this project without agrivoltaics.
Then I would correct that it is not PPRP approval. It is the secretary or the commission has the authority to approve or disapprove. This is the state recommended licensing condition.
Okay. So then when you said that the PPRP would recommend approval of this project without agrivoltaics, are you now backing away from that statement?
I'm going to back the statement, not backing on the statement, but I would affirm that if the agrivoltaic is approved, if the agrivoltaic is employed, this is what we recommend approval.
Okay. And if it's not employed, this document on that subject is silent. Am I right?
That is my understanding.
Thank you. I have no further questions. Thank you very much.
Regardless of whether it's PPRP doing the approving or the signatures of the letter doing the approving, is it your testimony today that PPRP is recommending approval regardless of whether or not agrivoltaics happens on the property?
I have to think about it for a second. It is that in PPRP position, given that PPRP does not recommend agrivoltaic in any project that is not co-locating under the public utility articles that I mentioned before. So it is not PPRP position to really enforce the project or recommend the project to be required having agrivoltaic. So it is. That's why we put an if, and then if the PSC or Your Honor leave it up to Your Honor discretion to see if it should be.
I understand.
Granted, you should be enforced or not.
I understand. Thank you. Mr. Tolson, any follow-up?
Just a few questions, Your Honor. Ms. Picow, this project is not a co-located project. Is that accurate?
That's accurate.
So the citation to the public utilities article you mentioned, 304, is not applicable.
It's not applicable to these projects.
So agrovoltaics are not required for this project.
That is correct.
And therefore, it is the recommendation of the Secretaries of the Maryland Department of the Environment and Natural Resources that this project can be approved by the PSC with or without agrovoltaics.
That's correct.
Thank you.
Okay. Once again, I understand that the project can be approved by the PSC with or without agrovoltaics. My question is it true that the recommendation of PPRP is not dependent on whether there's agrovoltaics or not?
That is true, Your Honor.
Okay. Okay, thank you.
Thank you.
Any other witnesses? Oh, you can step down. Thank you. I appreciate your.
Thank
no,
you.
Your Honor. That concludes PPRP's presentation.
Thank you. Montgomery County.
Yes, good morning, Your Honor.
Good morning.
I would like to mark for admission Montgomery County's Exhibit Number 1, which we had filed on May 15th of 25, mail log number 318858. It's the written comments of the county executive and the president of the county council with 2 attachments, one being the impact report of Montgomery County solar collection systems in the AR zone, and the other being section 3.7.2.
Montgomery County 1 is marked. Is there any objection to its admittance at this time?
No, Your Honor.
Montgomery County 1 is admitted. I have some questions, and I know you don't have a witness. So I'm going to ask my questions of you, and hopefully you'll have the answers. So Montgomery County's letter is dated May 15th. At the time the letter was written, was Montgomery County aware of the Park and Planning April hearing and the May 13th letter?
I don't have information on that, Your Honor, at this time. I can take a data request if you'd like to.
Can you explain to me the relationship between Montgomery County and the Maryland National Capital Park and Planning Commission?
Well, I know there are Montgomery County representatives on the MNCPB, but I don't know the...
I can help with that, Your Honor.
Sure.
I get asked this question a lot, as you might imagine. Yeah, the Maryland National Capital Park and Planning Commission, not to be confused with the National Capital Planning Commission, is made up of 5 representatives, the Prince George's County Planning Board and the Montgomery County Planning Board. And the vast majority in Prince George's County, all of the county except the city of Laurel, and in Montgomery County, the majority of the county, with the exception of certain municipalities, Rockville, Gaithersburg, and some others, fall under the zoning authority of the planning boards. And the county council, which in that case sits as the district council when they're making zoning decisions. So development applications within what we call the regional district, which is the portion of Montgomery County under which the jurisdiction of the planning falls under the jurisdiction of the planning board. All development decisions go through the planning board, and the planning board makes zoning recommendations to the county council, once again sitting as the district council. I apologize, I know this is not a model of clarity, for zoning changes within that realm. But in the case of this project, because utilities, public and private utilities, are not generally subject to zoning due to preemption, they go through the mandatory referral process. And that is why Chaberton came to the planning board and filed a mandatory referral application, and which the planning board heard. The only regulatory the mandatory referral process results in a non-binding recommendation. The only actual regulatory authority the planning board has in this instance is the forest conservation plan. That is the only thing that the planning board has the authority in its own right to enforce. I hope that helped.
It does.
It's been this way for almost 100 years.
Okay.
I do believe I know I had some communication with the planning board, specifically with respect to what you were asking about. The planning board hearing was on April the 24th. I know there had been some communication with the county attorney's office about what happened at the hearing, et cetera. I don't know if they had seen, I don't remember if they had seen this letter before the county's letter, the planning board's letter before the county's letter was drafted.
It was just 2 days later.
Yeah, so and it's been a while, so I really do not recall whether or not the author of the county's letter had seen the planning board letter yet.
Does I'll wait and ask you a question in a minute.
Sure.
I have no further questions for you. Thank you for your time. And Montgomery County's exhibit is admitted, if I didn't already say that. Staff?
Yes, thank you, Your Honor. Staff has one exhibit to mark. It's the direct testimony of Roger Austin, filed on May 15th under mail log number 318896.
Staff Exhibit 1 is marked. Any objection?
No objection, Your Honor.
Staff Exhibit 1 is admitted. Do you want to make Staff Exhibit 2 the one page, the conditions on one page? Or do you just...
I mean, it is the same recommendations from our testimony, but I can if you like.
That's fine. Okay. Anything else from staff?
Nothing else from staff.
Okay, park and planning.
Yes, thank you, Your Honor. I would ask that our exhibit be marked as Park and Planning Exhibit 1, which is the previously mentioned planning board letter recommending approval with proposed conditions of May 13th, 2025, and mandatory referral number MR 2024-017 and Forest Conservation Plan number F 2025-0480, docket 68, mail log 318865, filed on May 15th, 2025.
Park and planning exhibit is marked. Does anyone have any objection to?
No objections, Your Honor.
No, Your Honor. No objection.
Hang on just one second. I've misplaced it. Park and planning 1 is admitted.
Thank you, Your Honor.
So, does park and planning participate in decommissioning?
No, Your Honor.
The second, in the letter, the second condition is a stormwater management plan.
Yes, Your Honor.
Have you reviewed PPRP's conditions? Well, they have several water conditions. I have in my notes 14, 15, 16, and 21. But are PPRP's conditions sufficient?
I saw them at the time, Your Honor. I do not have them in front of me. I don't know if someone here has a copy I can take a look at.
You can pass those down.
Thank you. I'm sorry, Your Honor, which?
Let's see. I have several in my notes. Let me
I think you said 14, 15, and 16?
15.
15, okay. Yes, Your Honor, I believe 15 would cover it.
Okay. At the April, were you at the April meeting?
I was, Your Honor.
Was the condition of agrivoltaics, was the type of agrivoltaics discussed?
To the best of my knowledge, there was some discussion back and forth, but I don't believe it was the type was discussed in any excruciating detail.
So, if the applicant planted pollinator-friendly grasses underneath of the solar panels, would that be sufficient?
To the extent that I can speak for the planning board majority, I do believe it would. I know that the board majority wanted the applicant to coordinate with the county Office of Ag. So I believe the feeling was that if it was okay with the Office of Ag, that it would be okay with the planning board.
Okay.
Because the Office of Agriculture is viewed as essentially the experts in this area.
So the condition says the applicant must implement agrivoltaics on the property in a manner capable of being enforced by the Public Service Commission.
Yes, Your Honor.
Was the type of enforcement discussed?
No, it was not. I'll try again. I had a sneaking suspicion I was going to get a question about this. This goes to what I was saying about the board's authority. Because of the nature of the mandatory referral process, there's no enforcement authority with their recommendations beyond forest conservation. Agrivoltaics do not fall under forest conservation. The board majority, chair in particular, were concerned that they wanted an agrivoltaics requirement to be able to be enforced. And this language is a result of that concern. That the idea was that the PSC would, in its own right, be able to enforce such a requirement because the board does not have that ability.
Are they asking the PSC to enforce that it's a condition, or are they asking the PSC to enforce if agrivoltaics starts and stops?
To the extent that I can speak for them, Your Honor, I believe it would fall into the latter category.
Okay.
And I'm engaging in retroactive mind reading as best I can.
I understand. So 7203 requires the commission to look at local government's recommendation.
Yes, sir.
And I have two local governments here that work hand in hand. So whose recommendation do I look at?
Well, I guess everyone's, Your Honor.
I knew you were going to say that. Were you also at the planning board meeting on January 9th, 2025, when 9726, the Sugarloaf project, was discussed?
I was, Your Honor.
Okay, so these projects were heard 3 months apart, and one had a 3-2 denial and one had a 3-2 approval.
Yes, Your Honor.
So what's the difference?
The vote of the chair shifted.
Do you have an idea of, based on the meeting, if it had to do with the size of the project in megawatts, or the size of the project in acreage, or the situation of the projects, near to a road or far from a road, or near to other residences or far from other residences, or?
To the best of my knowledge, Your Honor, I believe it was, I can't swear to this, but I believe it was mostly an issue of the size of the project, as in the acreage.
Okay. I noticed some language in the recommendation report.
The staff report?
Yeah.
Yes.
About, and if you need a reference, I can find it, but it'll just take me a minute because apparently I didn't tab it. about reconsidering the size requirements for the AR zone.
Yes, sir.
Was there a recommendation about that?
I believe I know there had been a lot of discussion. The planning staff was of the opinion that the county should reevaluate its the zoning text amendment that dealt with solar projects in the ag reserve. So I don't doubt that there probably is some language in here to that effect, but I don't remember where exactly it is.
So does the fact that that language didn't make it into the letter, does that mean that it was denied, or does that mean that it just was not affirmed?
I'm sorry, Your Honor, I don't denied or affirmed by the planning board?
Yes.
Yeah, what we ended up in a somewhat tricky situation because the staff was recommending denial, and the staff report was published in advance of the hearing. So once the staff report is out there, it's out there. It's not altered retroactively. And then we had a planning board decision that recommended approval. So not all the language in the staff report is consistent with the language in the letter for that reason. So the planning board planning board majority included in this letter what was important to it, and there, like I said, because we had a staff report recommending denial and a board decision recommending approval, there are some inconsistencies.
Okay. Okay, I understand. I'll tell everyone I'm leaving the record open this case for a little while in case I have some further questions that I didn't think about when I was sitting up here today. And I may have some further questions for you.
I completely understand that, Your Honor. I've done the best I can.
Thank you, I appreciate it. I know I put you on the spot.
Over the course of months, and thank you for giving me a copy of that.
All right. Okay, the combined interveners.
Yes, Your Honor. We have several exhibits. The first is the testimony of Caroline Taylor on May 15. It is mail log number 318868. And, Your Honor, we can mark that as Intervenors Exhibit 1. She also has two documents attached to her testimony, and I'm content to have Exhibit 1 include her testimony and those two documents, unless Your Honor wants those two documents to be Exhibits 2 and 3.
It's fine for the Lecklider direct testimony to include the attached exhibits, and those will be marked as Exhibit 1.
Okay, this is the Taylor testimony.
Oh,
Your
I'm
Honor.
sorry, the Taylor testimony.
And the Lecklider testimony on May 15 then would be Exhibit 2.
Okay.
That's also included in mail log 318868.
Exhibit, Intervenors Exhibit 2 is marked.
And then Exhibit 3, Your Honor, to be marked, would be the rebuttal testimony of Caroline Taylor, which was given on July 1, and that is mail log 320112. That would be Intervenors Exhibit 3 marked.
So I think that's surrebuttal testimony.
Correct.
Caroline
Oh,
Taylor.
yes. I'm sorry, yes,
Okay,
surrebuttal.
so the surrebuttal testimony will be marked as Intervenor Exhibit 3. Is there any objection to the admission of these exhibits?
No objection, Your Honor.
Intervenors Exhibits 1 through 3 are admitted.
Good, Your Honor, I'd like to call Caroline Taylor to the stand.
Excuse me, Your Honor. Before we do that, maybe we have a 5-minute break.
Yes. Yes, we can go off the record for 5 minutes.
Thank you.
not saying they might not at some point, but off the top of my head right now, I don't think they have any records. I could be wrong, but because I think they rely on the state. And at this point, it's a little bit hard sometimes to keep track of what was proposed versus what was actually enacted.
Oh.
When you were gone, that's fine.
Is there a bond, and has been a bond?
Call Sandra to cover it.
But in the part that I have to do, it's not that actually give her this one. But then open record meeting.
Mm-hmm.
Let's just finger crossed, hopefully it will happen in the next 14 days.
I think it will.
Even if it won't happen soon, she won't.
Yeah, I mean, I'll be gone from the 15th to the 29th, so if it happens, just tell them, we're not here.
Ask someone to get back. Just ask next time.
Mhm.
Yeah, I don't know. Oh.
But yeah, just to make sure that before I do that, we're all on the same page.
Sure. Okay. This building's gonna collapse, I think. Well, my client keeps their office at 62 degrees because their HVAC doesn't, they've redone the inside of the building so the thermostats don't align with the spaces. People go hypothermic when they're in the thing, but it's pretty cool in here, you know, for a state that's trying to save energy. Pretty odd, huh?
I was gonna say the Department of Energy has icy cold buildings.
Natural resources, yeah, it's cold. Are you replacing Lisa Sullivan on all these cases?
Lisa Brennan, yes.
Lisa Brennan, I'm sorry. So I'll just note that I've seen some of the substitution stuff that were put in.
For all of them, as of now, I'm the only person that's.
So we'll copy you on anything that comes
Yes,
in.
please.
Okay,
No,
I just,
we had to submit them all individually because the mail lists are all different, and there's no way to blanket.
yeah, no, I just,
You just have to keep.
I kind of figured, I saw your name on a few of the other things. I just want to make sure that we keep you posted on all these.
Thank you.
Everybody now. We can go back on the record.
Please raise your right hand. Do you swear or affirm under the penalty of perjury
Ms. Taylor, good afternoon. Please tell us your occupation.
I'm an executive director for a nonprofit named Montgomery Countryside Alliance.
And are you here on behalf of all of the interveners in this case?
I am.
Did you provide testimony in this case on May 15?
I did.
And did you provide rebuttal testimony in this case on July 1?
I did.
Have you recently reviewed your testimony?
I did.
Did you prepare that testimony yourself?
I did.
If I asked you the same questions today that you were asked in your May 15 and your July 1 testimony, would you give the same responses?
Yes.
Your Honor, I would like to move the admission of interveners Exhibit 1 and 2 at this time, which would be her testimony, or do you want me to wait until the end?
No, it's fine. 1 and 2 are admitted.
Good. Now,
Excuse me, 2 is Lechleiter's direct. It would be 1 and 3, right, or direct and rebuttal?
Yeah, but I asked earlier if anybody objected to 1, 2, and 3, and everybody said no, so I already admitted them.
Okay, I just want to make sure I keep clear.
if all those 3 are admitted, Your Honor, then I'll go on. Are they admitted?
They are admitted, yes.
Good, thank you. I have no further questions.
Okay. Park and Planning,
No questions, Your Honor.
staff,
No questions, Your Honor.
Montgomery County,
No questions, Your Honor.
PPRP,
No questions, Your Honor.
Chaberton.
Yes, please, Your Honor, a few
Go ahead.
questions. Thank you. Good afternoon, Ms. Taylor.
Good afternoon.
My name's Andy Flavin with Trout and Pepper Lock, and I'm here representing the applicant. Nice to see you again. And most of my questions for you are in your rebuttal, but before we get there, I do have just 1 or 2 questions for you regarding your direct testimony. So to start, could I ask you to please please turn to page 10 of your direct testimony?
Okay, I'm there.
Okay, and I'm looking at line 70. It's up towards the top. 170. It's up towards the top of the page.
Wow, my lines may be different than your lines here. Can you direct me?
So it's right under the Roman numeral 5, non-viability of proposed alternatives to ZTA.
I'm so sorry. I feel like this is printed out strangely here. Hold on. Oh, here it is. Non-viability.
And it starts with the question, are agrivoltaics a recognized exception under the ZTA? Do you see that?
Yes.
Okay, and then on the line immediately below that bolded question, your testimony states agrivoltaics is not a recognized exception under the ZTA and should be rejected on that basis alone. Do you see that?
Mm-hmm.
Okay, and have you been in the room today?
Yes.
And so you're aware that the Montgomery County Planning Board of the Maryland National Capital Park and Planning Commission, or the Planning Board, voted to approve the mandatory referral application associated with this project by a vote of 3-2?
Yes.
Okay, and are you aware that the Planning Board found that requiring agrivoltaics on the property was, with specific enforcement authority in the hands of the Public Service Commission would be a mitigating factor allowing for approval?
So I recognize in their non-binding mandatory referral that they did make that decision.
Okay, thank you. That's all. That's all I wanted to ask you about your direct testimony. Could I get you to turn to your rebuttal testimony, please? And I need to get it myself too here. And with your rebuttal, could I please ask you to turn to page 3? And at least on the version that I printed out,
Right.
It's starting at line 7, which it's right under the bolded question. What is your response to Mr. Boswell's statement that the interveners concerned are overstated? Do you see that?
I do.
Okay. And so starting here at line 7, and then it continues on to page 4, I believe you respond to a statement made in Mr. Boswell's rebuttal testimony that the interveners concerned are overstated because if approved, this project would impact approximately 11 acres out of the roughly 93,000 agricultural reserve. Does that sound right?
Yes.
Okay. And then could I get you to turn over to page 4? And I'm looking at line 3. It's the start of a new paragraph. It says without proper safeguards. And so that says, and I'm looking at that paragraph here, lines 3 through line 6. Without proper safeguards, solar projects will displace critical farmland in the reserve. Approval of the project will result in a ripple effect whereby farmland with prime soils, Class 1 and Class 2, will be covered with solar facilities rather than used to grow food, contrary to decades of reserve planning and preservation. Did I read your testimony correctly?
You did.
Okay. With that topic in mind, could I ask you to just jump ahead for a moment really quickly to your page 7 and footnote 10? And it refers to it looks like a link to a Montgomery Countryside Alliance website. And Your Honor, I have printed copies of that website that I can share with folks in Your Honor.
Absolutely. Please give it to the witness first.
Absolutely, Your Honor. Thank you.
Thank you.
Thank you.
Thank you.
Now, Ms. Taylor, does this printout that I just handed to you, does this look familiar to you?
Yes, it's from our website.
Okay. And is this the document that you referenced in the
It was in the
link?
footnote.
In the footnote,
Yes.
okay, thank you. And you're the executive director of the Montgomery Countryside Alliance, right?
Yes.
And this article here, or this post, is dated July 1st, 2025. Does that look right here?
Yes.
Okay. And that's the date that you submitted the rebuttal testimony, right?
Yes.
Okay. Can I ask you to look at the very first paragraph of this post here that says, with the passage of Senate Bill 931, 5% of each Maryland county's protected areas, farmland, stream buffers, and forests are now prioritized for solar production. Do you see that?
I do.
Excuse me. And I think that this reference is to the provisions of Senate Bill 931 that were enacted as Public Utility Article Section 7-218. Does that sound familiar to you?
Very familiar.
Okay. And specifically, I think that refers to, or your reference to the 5% here refers to PUA 7-218H4 Romanet 1, which states in relevant part that the total combined number of solar energy generating stations that may be approved for construction in a priority preservation area that was established before January 1, 2025 shall be limited in area to 5% of the total acreage of the priority preservation area. Does that sound right?
Yes.
And does that sound like the reference that you made?
That
here
is
in this?
that is the reference.
Okay. And so going back here to this post from the Montgomery Countryside Alliance, there's a statement at the bottom of that first paragraph that says, here in the Ag Reserve, that number looks to be around 5,000 acres. Is that right?
That's correct.
And so the Ag Reserve, or at least a substantial portion thereof, is a priority preservation area, right?
The entire Ag Reserve is a priority preservation area.
Okay.
Established in 1980. Yes.
Okay. And then so with this passage and enactment of Senate Bill 931 that you reference here, the General Assembly limited the development of solar in the agricultural reserve to 5% of the total acreage. which here you suggest is around, or this post suggests is around 5,000 acres, right?
That was the math, yes.
Okay. Could I ask you to please turn to page 6 of your sir rebuttal testimony? And I'll have a few more questions for you regarding this post, but for now,
I'll set it to the side
don't
for
need-
now.
Thank you. So page 6 of your sir rebuttal testimony, starting at line 8, it's under the bolded question. Mr. Boswell states that delays associated with the PJM interconnection process generally should not affect solar projects that interconnect with the electric distribution grid. Do you have a response? Do you see where I'm referring to?
I do.
Okay. And then starting on, I guess, my line 9, or I guess starting on my line 8, you note that the agricultural reserve is comprised of 3 electric service areas, Potomac Edison, the Baltimore Gas and Electric, and Potomac Electric Power Company, or PEPCO, right?
Correct.
Okay. And then starting on line 10, you state that according to Montgomery County's Office of Agriculture, since the passage of ZTA 20-01, as many as 10 solar projects in the reserve have been turned away by Potomac Edison, citing the PJM interconnection queue backlog. Do you see that?
I do.
And you didn't provide any specific citation to that statement, right?
No, the statement is born from a conversation with the Director of Office of Agriculture to ask him for those statistics prior to filing the sir rebuttal testimony, but I don't have a citation.
Okay. And so you don't know the size of those 10 solar projects that apparently were turned away by Potomac Edison?
I can tell you that those projects would have complied with the terms, the requirements of ZTA 2001, so they would have been 2 megawatts or less.
Okay.
So just to be clear, those projects were in the queue under the conditions of the, at the time, county legislation.
Okay, so is it your testimony then that at least based on your understanding of your communication here with the Montgomery County Office of Agriculture, that projects below 2 megawatts in size were in the PJM queue, the PJM interconnection queue?
I think I'm not quite understanding. The first question you asked me is what was the size of those 10 projects?
Yes.
My answer was, my understanding was, because they complied with all the conditions of our zoning text amendment, they would have been 2 megawatts and smaller. Now I'm trying to understand what your second question.
Certainly. So based on your understanding that those projects, that those 10 projects were 2 megawatts or smaller, and that those were projects that apparently were turned away by Potomac Edison, citing the PJM interconnection queue backlog, I want to understand then, is it your testimony that those projects, solar projects that were less than 2 megawatts or less in size, were in the PJM interconnection queue?
I cannot answer that question. I can only convey what was shared with me with my Office of Agriculture, which is that those projects were right at the front gate told, we're not going to move you forward.
Okay.
And that was per Potomac Edison.
Potomac Edison, okay. Thank you. Would you agree with me that this project is proposed in PEPCO service territory?
Yes, it is.
Okay. And are you aware that the applicant submitted a fully executed interconnection agreement between PEPCO and the applicant with Mr. Boswell's rebuttal testimony?
Yes, I am.
And would you agree with me that, subject to check, this project did not need to go through the PJM interconnection queue?
I can't answer that question.
Okay. And you testified previously in the docket considering Chaberton Solar Sugarloaf 1 LLC CPC application, right?
Correct.
And would you agree with me, subject to check, that the Sugarloaf project is proposed in Potomac Edison service territory?
Correct.
And would you agree with me, subject to check, that the applicant in that case, in the Sugarloaf case, submitted a copy of the executed interconnection agreement with Potomac Edison, included with Mr. Boswell's rebuttal testimony in that case?
That was the representation.
Okay. If I could get you next to look at line 17 on page 6 of your sir rebuttal. In this, it starts with the paragraph, the applicant repeatedly portrays the county's enactment of the ZTA as the most significant barrier to advancing solar projects in the agricultural reserve, but the facts won't bear this out. Do you see that?
I do, and I'm actually glad that you pointed that sentence out.
Okay. And I think then going on to page 7, you discuss a solar industry study cited by, and it was attached to Mr. Boswell's rebuttal testimony.
Mm-hmm.
And then starting on page 7, line 2 of your rebuttal testimony, you reference owner willingness, right? Do you see that?
Yes.
Okay. And then on line 4, you state that landowner unwillingness to rent to solar companies can't logically be traced to the enactment of the ZTA 20-01, which in fact opens the door to solar projects. Do you see that?
I do.
Okay. So putting aside whether Mr. Boswell's rebuttal testimony or the industry study referenced therein actually attempt to trace landowner willingness to the ZTA, you'd agree with me that property owner willingness to lease or sell land for solar development is a critical consideration regardless of where a solar project is proposed, right?
Yes.
Okay. And then moving down to line 8 here, you state that it's beginning at the very end of that sentence. Moreover, the applicant's assertion in the back of the envelope math to support it are at odds with facts and county mapping, that projected availability of 4,462 acres of land for solar projects within the agricultural reserve that conform to the provisions of the ZTA. Moreover, the county mapping shows over 8,200 acres of warehouse and parking areas that could host solar facilities. Did I read your testimony correctly?
You did.
And I think you include two footnotes there that cite back to the post from the Montgomery Countryside Alliance website we were just discussing. And so turning back to that post, on the first page here of this printout on under number 1, and this is, it states that county planners found that there are 445 properties totaling 4,462 acres that meet all of the ZTA standards, not prime soils, unforested, no steep slopes, no stream buffers. Do you see that?
I do.
And it also states, this is on the second page of the printout, under that first map, that 3,010 acres are located within 2 miles of a transmission line and meet the ZTA standards, right?
Correct.
So you'd agree with me that as it's currently written and enacted, ZTA 20-01 prohibits all solar systems greater than 2 megawatts AC in the agricultural reserve, right?
No, I need you to repeat that question, please.
Would you agree with me that the ZTA 20-01 prohibits all solar systems greater than 2 megawatts AC in the agricultural reserve?
Correct.
Okay. And that's regardless of the type of soil it's on, right?
Right.
Okay. So a solar developer couldn't build a solar system greater than 2 megawatts on that 4,462 acres of land to otherwise meet the ZTA requirements, right?
Under the terms of ZTA 2001 as written and enacted, yes.
Okay. And with respect to that 4,462 acres that that apparently meet the ZTA standards, the analysis here, it didn't consider whether the existing electrical infrastructure nearest these properties could electrically accommodate solar interconnections, right?
So I appreciate the line of questions here because the material that we see here was provided. This is county material. They had a number of layers that they employed to determine the numbers of acres that would be available for solar. As to your question with regard to whether this is 3-phase or whatever in proximity, I cannot with certainty answer that question.
Okay. And I think you, but just to be clear, I think previously you pointed in this that this analysis the county did, this 4,462 acres, looked at not prime soils, unforested, no steep slopes, no stream buffers, right?
Right, and if may I give a couple more sentences in this answer? The point of the county mapping in advance of ZTA 2001 was to determine whether the conditions that were being proposed would be so onerous as to prohibit solar. Their mapping, their investigations determined that it would not be. My answers in my sur rebuttal in my direct testimony on this issue was to demonstrate that there was due diligence on the part of the county and indeed those advocates for the zoning text amendment ZTA 2001 as amended were based upon a number of inquiries to determine that there would still be land available under all of those conditions for community solar in the agricultural reserve. There was that, I cannot stress that enough. We did as much as we could possibly do to ensure that this was not a prohibition to solar, but rather a provision in an area that previously prohibited solar.
Okay, and I guess just, because you reference these numbers and say that the industry analysis essentially is not supported by these numbers from the county analysis that you cite in your sur rebuttal testimony, I think it's worth exploring, and that's the reason for my questions, exploring the level of diligence that was actually put into that analysis.
Understood.
Okay. And so this analysis, to your knowledge, that you've cited here in your sur rebuttal, it didn't consider how much it would cost to upgrade or extend the necessary electrical infrastructure to support these interconnections, right?
No, I don't think that the county engaged in that. By my understanding, I don't think they engaged in cost to industry.
Okay. And the analysis didn't consider whether there might be protected species on these properties, right?
I actually cannot answer that, but I would say I can look that up if you'd
Okay.
like.
That wasn't a factor identified in your analysis or in your testimony characterizing this analysis,
We did
right?
not. There were several factors that in our position on this issue we did not bring up. One was endangered species.
Mhm.
The other was effect on view shed. Neither
Okay.
of those were primary to our concerns.
Sure. And that analysis then didn't consider whether there might be protected cultural or architectural resources on these properties, right?
I believe the county did factor that in.
Okay, but that's not reflected here in the
No,
testimony that you cite.
this is a distillation.
Okay,
Not
and there's
just to be clear, not every layer is provided here. There were multiple layers that the county employed in coming up with the acreage that they
okay,
came up with.
but that 4,462 acres, that doesn't include that amount in there, right?
You're asking me to say that doesn't include cultural or
Correct.
historic? I cannot answer that because, as I said, there were more layers that were employed by county staff in order to come up with that total.
Okay. In this analysis, it didn't perform any Phase 1 environmental site assessments on these properties to determine whether there may be environmental conditions precluding development, right?
No, these
Okay.
were in-office map layers that were employed.
Sure. And the analysis didn't consider whether the owners of these 445 properties would be willing to lease or sell their property for solar development, right?
No.
Okay. So if I could then next ask you to move on to number 2 on this printout. It starts at the very bottom of the second page, and it's large rooftops are plentiful for solar throughout the county.
Yeah.
And it references more than 1,600 acres of large rooftops that purportedly are available for solar, right?
Correct.
To your knowledge, this analysis didn't consider the age of those rooftops, right?
As to the viability of those structures, I cannot answer that question.
Okay. And so I assume your answer to my next question would be the same, which is whether those rooftops are structurally capable of supporting a large solar system.
I cannot answer that question.
Okay. And this analysis revealing 1,600 acres of large rooftops didn't consider the proximity to electrical infrastructure that could support large solar installations, right?
Cannot answer that question.
Okay. It didn't consider potential obstructions on rooftops or on adjacent buildings that could impede the amount of solar that could be installed, right?
That question I cannot answer.
Okay. And it didn't consider whether the property owners would be willing to lease their rooftops for solar, right?
Right.
Okay. In this section here, it's at the top of the third printout, it references another 1,415 acres underneath Pepco-owned transmission lines, areas already cleared of trees and not being farmed. Do you see that?
I'm sorry, which page? Where?
It's on page 3 of the printout from the website post, towards the top.
Okay.
And it's
Yes.
that block of text there between the two images. And so it references this 1,415 acres underneath Pepco transmission lines. Have you ever tried to build a structure under electric transmission lines owned by an investor-owned electric utility?
No, but I'm happy to report there is a team of engineers now exploring the viability of co-location under those lines. So
Okay.
I'm eagerly awaiting their the results of their study.
Okay. And to this point, this analysis revealing this 1,415 acres beneath Pepco transmission lines, that doesn't consider whether Pepco or the property owners of that land under the transmission line would be willing to grant the necessary land rights to develop solar, right?
No, it does not.
Section 4 is towards the bottom of this page, references over 6,000 acres of surface parking lots and parking garages in Montgomery County that apparently could be used for solar. You see that?
I do.
And this analysis, to the best of your knowledge, didn't consider proximity to electrical infrastructure that could support large solar installations, right?
It doesn't. It should be noted there have been several successful installations developed in Montgomery County on parking lots. And as in the entire realm of what we're discussing here, so much of this is new, experimental, if you want to use that word. And so we are eager and hope to see that more of these previously degraded or impervious surfaces will be used for this use. And it's not to say greenfield should not be. It's just to say that all of the above should be used, right?
And can you tell me this analysis regarding the parking lot acreage, it didn't consider potential obstructions nearby, like trees or other buildings that could limit the amount of solar that could be installed, right?
Not to my knowledge.
Okay. And it didn't consider whether property owners would be willing to lease space in their parking lots or parking garages for solar, right?
Again, not to my knowledge.
Okay. Your Honor, those are all the questions I have. Thank you.
Suppose, for the sake of argument, that for this project, Chaberton installs 10-foot poles, probably taller than that, 15-foot poles. They spend the extra money for tall poles. And they employ tilting panels so that, the sun can get to the ground underneath of the poles. And they grow corn, which, normally you can't have under solar panels. And then around that area, they plant pollinator habitat, and they have apiaries. And they bring in sheep to graze to keep those areas, those pollinator habitats down. Your position would still be the same, would it not?
In this particular project, I would have to say yes. Moving forward, however, with this industry, and we've said this before, our goal has been to provide the science that will show that all of those things can happen here. It's just simply not demonstrated, and we were hoping that we would get that study from the Agricultural Research Lab in Beltsville, which is now going to be shuttered by the federal government. So the answer is we would remain opposed to this because there's no demonstration currently that those things can happen there. We were working with the county executive on the Site 2 landfill to have a test project with a company that said they could do some of the things you just said in terms of tilting panels that provided for commodity production, but that project has not moved forward yet.
Okay, thank you. I don't have any further questions.
Thank you very much.
Wait, hold on a second. Council, do you have any redirect?
I don't, thank you.
Okay, thank you for
Right,
your
very much
appearance
appreciate
today. Mr. Mills, where do appeals from the Maryland National Capital Park and Planning Commission go? With regards to Montgomery County?
For mandatory referrals, the reason I said regulatory approvals go to the Circuit Court for Montgomery County. Appellants, they file a petition for judicial review. Mandatory referrals, there is no appeal. it starts and ends with the planning board, and that's pursuant to state law.
Okay, thank you.
And one other thing, Your Honor, if I may, you had asked to, I don't think it likes me. You had asked about language in the staff report about the county potentially changing the zoning law for solar projects. I went through it very thoroughly. In the meantime, I did not see any language. That might have been in the staff report in the other Chaberton
think it
case
might have been.
in 9726. And one final thing, if you don't mind, since I'm on, I wanted to wish a happy 14th birthday to my daughter Elise, who probably isn't watching, but I just wanted to, I wanted to try. Thank
Happy
you.
birthday, Elise.
Thank you.
Mr. Tolson. Language in DPRP's conditions has come a long way in the past 6 months. I would ask PPRP to, without changing the conditions, update the language in its recommended license conditions. I think folks at PPRP, some of the analysts will be familiar with what's been issued in recent cases.
And you'd like to see clean and redlined?
Yes,
file?
please. Yes, please. Mr. Flavin. The commission has to give due consideration to the recommendation of the local government. I have 2 representatives from the local government here, one who's saying no, and one who's saying only if there is agrivoltaics. The company's position is that you can't put the cart before the horse. You have to have a plan first, and then there can be some details about agrivoltaics. But agrivoltaics, I mean, there's, the pollinator habitat that everybody plants underneath just for, soil control. And then there's adding bees. And then there's, crops and the potential for grazing. These are all very different things we're talking about. So what is the proposal by Chaberton that would give the commission more assurance that it's guaranteed to Park and Planning that there would be agrivoltaics will happen, and not that even if as we heard on the stand today, that even if agrivoltaics don't happen, you'll still pursue the project.
May I have a minute, Your Honor,
Sure.
just to confirm? Your Honor, I think after discussing with my client, I think the applicant would propose that there be a condition requiring the applicant to implement agrivoltaics in consultation with the Montgomery County Office of Agriculture as was recommended in their condition. And if then that, based on that agreement, either that the parties can't agree on the type of agrivoltaics to be implemented, or if there are no viable responses to a request for an agrivoltaic project that meets what Montgomery County and the commission would support, that the applicant come back to the commission at that point and provide an update. And at that point, then the applicant could, with the commission's permission, try to present additional evidence about whether the commission should consider if the project could still go forward, even if it is unable to implement the agrivoltaics.
This is not a typical CPCN. It's in an agricultural reserve. Follow-up question.
Certainly.
If that happens and an RFP is issued and you or whoever buys the project starts with agrivoltaics and the water being brought in on the truck for the sheep is just no good, and so they want to skip town, what happens then?
Well, in my view, I think it would be in the to the extent that there's a licensing condition that requires agrivoltaics to be implemented, and if something happens to say it starts and, like you said, whatever is proposed and initially approved no longer works, then I think the applicant would have to notify the commission right away and come back and propose an alternative. And I realize it would be under the commission's discretion at that point, if that happens, to determine whether the operation should be paused until a new agrivoltaic.
The operation of the solar panels?
Yes. I think that would be within the commission's discretion. I'm certainly not advocating for that here, but to be clear, but I believe that would be within the commission's discretion, similar to other enforcement authorities it has with respect to project conditions.
Okay. Does anyone else have anything that they want to take up this morning?
Yes, Your Honor. I believe you stated that Montgomery County was against the project, but I'm reviewing their letter, and I don't see specifically where it says they wouldn't approve the project, just that they're asking the PSC to give due consideration to their local zoning.
Okay, thank you for that.
Your Honor, if I may, one additional thing. I just wondered if you wanted us to take as a bench data request your question about who is considered the local government under 7207, because the way I read it, it says that the commission is to hold the initial hearings with the coterminously with the county government or the municipality government of where the site is to be located, and that indicates that the drafters of that statute indicated that they wanted it to be the county government to be considered as the local government. So I
don't need a bench data request for that.
Thank you, Your Honor.
And Your Honor, we will just, on the clean and red line, RLCs do them as quickly as possible.
Yeah.
I mean, I know 15 days is the common outer period, but we'll try to get those done sooner.
15 days would be okay.
Your Honor, two very quick logistical questions. One, I just wanted to make sure, and I apologize if I misheard it, was the applicant Exhibit 43 admitted into the record?
I don't know, but it is now.
Okay, thank you. And the other thing I wanted to ask, and this realize it may be dependent on some of the additional questions that you say that you may have. Do we need to address a briefing schedule at this point?
Do you want to provide a brief?
I think we had initially thought about that.
Briefs are not required, but anyone who wants to file a brief. I apologize. I'm not using my phone to check my text. I'm looking at the calendar. 3 weeks from today is October 23rd. 4 weeks from today is October 30th. Can we do October 23rd for initial brief and November 6th for reply brief? I say the 23rd, October 23rd.
Thank you, Your Honor. That works fine for the applicant.
Anyone who wants to file a brief can. It's not necessary. Anything else?
May I make just one final
Sure.
point, Your Honor? I just wanted to counteract the assertions previously that the county was not opposed to this. It's stated in the first paragraph of the letter that we believe that it's not consistent with the current zoning. So I just wanted to
Yes, ma'am. Thank
put
you.
it on the record. Thank you.
I would just say, Your Honor, on the question of two local governments, one has been elected and the other has been appointed.
I was asking the two representatives from the local government. Yeah. Thank you. Thank you for that distinction. Anyone else?
No, Your Honor.
No, thank you, Your Honor.
Your Honor,
Right.
I'm just trying to tip the favor, and I'm just trying to tip the balance in the favor of the government that supports us.
I understand. I understand. All right. Well, thank you, everyone, for coming down to Baltimore today and for your time today. I appreciate it.
Thank you.
You can go off the record. I realized that I didn't get you the names of all the folks, so I'm going to get that for you.
Your Honor,